5 seconds to go. Start. This court has held that once a decree for possession has been passed and execution is delayed, depriving the judgment creditor of the fruits of decree, it is necessary for the court to pass appropriate orders so that reasonable means profits, which may be equivalent to the market rent, is paid by a person who is holding over the property. A bench of three learned judges in state of Maharashtra and another versus Supermax International Private Limited and others observed as under. The way this court has been looking at the relationship between the landlord and the tenant in the past and the shift in the court's approach in recent times have been examined in some detail in the decision in Satyavati Sharma versus Union of India 2008-5 SCC 287. In that decision, one of us speaking for the court referred to a number of earlier decisions of the court and in para 12 of the judgment observed as follows. SCC pages 304 and 5. Before proceeding further, we consider it necessary to observe that there has been a definite shift in the court's approach while interpreting the rent control legislations. An analysis of the judgments of 1950s to early 1990s would indicate that in majority of cases the courts heavily leaned in favor of an interpretation which would benefit the tenant. In these and other cases, the court consistently held that the paramount object of every rent control legislation is to provide safeguards for tenants against exploitation by landlords who seek to take undue advantage of the pressing need for accommodation of a large number of people looking for a house on rent for residence or business in the background of acute scarcity thereof. However, a different trend is clearly discernible in the later judgments. The learned judge then referred to some later decisions and in para 14 at SCC page 306 of the judgment quoted a passage from the decision in Joginder Pal versus Naval Kishore Behel 2002-5 SCC 397 to the following effect. The courts have to adopt a reasonable and balanced approach while interpreting rent control legislations, starting with an assumption that an equal treatment has been meted out to both the sections of the society. In spite of the overall balance tilting in favor of the tenants while interpreting such of the provisions as to take care of the interest of the landlord, the court should not hesitate in leaning in favor of the landlords. Such provisions are engrafted in rent control legislations to take care of those situations where the landlords too are weak and feeble and feel humble. Before concluding the decision, one more question needs to be addressed. What would be the position if the tenant's appeal revision is allowed and the eviction decree is set aside? In that event, naturally, the status quo ante would be restored and the tenant would be entitled to get back all the amounts that he was made to pay in excess of the contractual rent. That being the position, the amount fixed by the court over and above the contractual monthly rent ordinarily should not be directed to be paid to the landlord during the pendency of the appeal revision. The deposited amount along with the accrued interest should only be paid after the final disposal to either side depending upon the result of the case. It has been held that tenants shall be liable to pay a rent equivalent to means profit from the date they are found not to be entitled to retain possession of the premises in question. Stop.